Thank you everyone for joining us and welcome to the 2022 Law Day events presented by the Manitoba Bar Association and the Community Legal Education Association. First of all, we acknowledge that CLEA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, OG Cree, Dakota, and Dene people, and the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake 40 First Nation. We acknowledge that much harm was done in the past and dedicate ourselves to move forward in the spirit of reconciliation. The Manitoba Bar Association is a branch of the Canadian Bar Association, an essential ally and advocate for the legal profession. The MBA promotes fair justice systems, facilitates effective law reform, upholds equality in the legal profession, and is devoted to eliminating discrimination. The Community Legal Education Association is a charitable organization that provides legal information to Manitobans and believes legal knowledge is necessary for full and equal participation in our society. On April 17, 1982, Queen Elizabeth II and Prime Minister Pierre Trudeau signed the Canadian Charter of Rights and Freedoms, thereby guaranteeing fundamental rights and freedoms for all Canadians. In honor of this milestone, the Canadian Bar Association introduced Law Day in 1983 as a means to commemorate the event and educate the public about the legal system. In lieu of holding an open house at the Winnipeg Law Courts building this year due to the ongoing COVID-19 pandemic, we are pleased to present these legal education webinars to help members of the public navigate the legal system. Today, we are pleased to have Donn Pirie presenting Real Estate Law First-Time Homebuyer's Guide. Donn graduated from the University of Manitoba in 2001 and has since practiced law in Winnipeg for the past 20 years in private practice, as well as in-house with the City of Winnipeg and the Northwest Company. Donn currently practices law with the firm Darcy and Deacon LLP, specializing in corporation, commercial, and real estate law. When Donn is not at the office or driving his kids around, he volunteers with a variety of organizations, currently Winnipeg Youth Soccer Association and the Kidney Foundation of Canada. If you have any questions for the speaker, please use the Q&A function and any questions will be answered at the end of the presentation. Thank you again and welcome Donn Pirie.
Thank you very much. Everyone can hear me all right, I take it? Okay, hearing no objections, I will go with that. All right, well, thank you very much for the introduction and pleased to be here again with the presentation for Law Day on real estate. Just trying to share my screen. I think I finally got it. So I have a bit of a history. I used to give this presentation 20 years ago when I was first starting out back at the law courts, and flash forward, to now. We're doing this by Zoom, and I have an actual PowerPoint, no handouts or anything like that. But really pleased to be here. It's an honor to be speaking with you today. All right. So without further ado, let's just jump right in. So I'm asked to speak a little bit about real estate law. I just want to briefly touch on the fact that real estate is law. The law concerning real estate deals with the legal framework concerning the ownership and use of land. There is, of course, a couple different types of real estate law, broad category of commercial real estate law dealing with things like property development, leasing, farming, mining, and other resource uses. But the subject of today's discussion will be residential real estate. I'm going to touch very, very briefly on landlord and tenant issues, but then we will move into residential real estate, which we've put in brackets there, homeowners. The bulk of our presentation will be concerning the purchase of residential real estate, home buyer's guide. Just a general sort of disclaimer. This is a general discussion. We're going to talk about some legal principles, but also a lot of practical aspects of the process surrounding the purchase of residential real estate. None of this is obviously a fact-specific guide or anything that I want you to rely upon. If you have any legal issues, please do contact the lawyer who can investigate facts, provide a legal opinion specific to your situation. Please do not rely on anything that you hear today for the purpose of making any decisions concerning your property or your rights. So I talked about, again, some different types of real estate law. One broad category of that is leasing. So again, we talk about commercial space to a certain extent. And again, that's your strip malls, your malls, warehouse facilities, things of that nature. All of those are typically uses that where a tenant leases all or a portion of the land from a landlord over a certain specified period of time for a specified rent. Residential spaces, we think of things like apartment buildings, mobile homes, life leases, apartment or residential leasing or real estate in Manitoba is governed to a great degree by the Residential Tenancies Act, which is overseen by the Residential Tenancies Branch, specialized department of the government of Manitoba. The Residential Tenancies Branch is tasked with overseeing the legislation and has a role in resolving disputes between landlords and tenants. I can say that residential tenancies is a complicated area of the law, and there is a complicated regulatory regime that deals with the various rights and duties of landlords and tenants. So we won't talk about that to a great deal today, but I can say that the government of Manitoba, and specifically the Residential Tenancies Branch, has an excellent website with lots of helpful information if you're looking for further information on apartment leasing, either as a landlord or a tenant. Leasing in general, landlord and tenant rights in general, not necessarily apartments. So I'd encourage you to visit that website if you have specific questions or information you're looking for. So then we get down to the owned real estate. This is what's sometimes called fee simple ownership or titled ownership, owned real property. The key here is that there is a party who is listed on the certificate of title. The certificate of title describes a piece of land by description that can be verified at the land titles office or searched at the land titles office. The basic example that we'll be using a lot of today is owned real property described by certificate of title for a residential property. So your basic homeowner situation. But there are some different types of titled property, and the one example I'll bring up here is the condominium. Most of you know the condominium buildings, apartment style condominium buildings, several floors. You may ask yourself, how do you get a certificate of title for that land? Given that, if you're on the 5th floor, 3rd apartment down, you're not really getting title to a piece of quote unquote land. But the Condominiums Act and the legislation surrounding that, such as the Real Property Act, make it possible for a certificate of title to be issued for that condominium unit, again, which can be searched down at the land titles office by legal description, and you'll have reference to a plan of survey, which will give you an actual description of what that land looks like. We'll come back to the condominium in a bit. Another type of residential space where you have owned property is duplex situations where you have a party wall that separates two different units on the same certificate of title. And then, of course, we have the freestanding house or residential building, where we are going to spend the bulk of our time from now on. So when we talk about the purchase of real estate, there's a couple things that typically goes into the decision about purchasing real estate. So we've already talked about the difference between leasing property and owning property. And presumably if you're on the side of, I want to purchase property, then you've already decided you don't want to lease. So now you're looking at, all right, I'm going to purchase a piece of real estate. What type of real estate would I like to purchase? That's your initial consideration. Am I looking at a condominium purchase, the duplex townhouse, the freestanding house, each of which has their own rights and obligations as they come with that certificate of title? The condominium certificate of title gives you a description of a unit, a piece of land, but it also gives you an interest in the condominium corporation, a voting percentage, and interest in the common elements. In that circumstance, you share a lot of the quote unquote real estate with your neighbors, the real estate consisting of the common elements being the parking lots, the hallways, the elevators, things of that nature. All of that is shared with your neighbors in common. The duplex, as I already mentioned, sometimes you have situations where you have two attached buildings separated by a party wall. Again, you have certain rights, but certain obligations in that ownership situation. And then the last is the freestanding house. This is a situation where you own a defined piece of land with a building that's situated on it for residential purposes. So all of those considerations, what type of property you're looking for, will go into your initial considerations there. But probably one of the more important considerations, not so much what property type you want, but what can you afford? And that's when the financing steps in. Most people, when they purchase their first residential property, will be doing so with the assistance of a mortgage. Most people aren't paying cash these days for a house. If you are in the market for a piece of residential real estate, most people will typically go to their bank or financial institution, credit union, you name it, and get a pre-approval. This pre-approval typically is an initial background search that is done by your financial institution to confirm whether or not your income, your debt, your household income, your household debt can actually support a loan to you. Do you have enough income to support the repayment of that mortgage and all the other things that come along with the purchase of real estate, things like taxes, utilities, maintenance? Are you going to be able to support all those things? So that's why people will typically, after that initial visit with the bank, they'll walk out with a pre-approval for up to X number of dollars. That's the amount of that they can borrow from the bank. As important in the pre-approval, or going right along with the pre-approval process, is a property appraisal. So before the bank will move to a full approval, or what will come to later, which is called the commitment, the financial institution is going to want to value the property that you're looking at buying, basically to confirm that there is actual value in the property. So you write up the offer to purchase for X number of dollars. The bank is going to want to send someone out to take a look, just confirm that actually there is a building on that property, and the amount that is stated to be the purchase price and the offer accurately reflects the building on the property. There isn't just a lean-to or a little shack that's there that is being bought for $400,000. So that leads you into what I guess would be considered the final approval process. So now that you've got an offer to purchase, the bank has given you the pre-approval, they've done the appraisal, they're satisfied that there's an actual residential property that has value that they're going to loan you money on. What do they need to do for the final approval? This is where the bank is now getting into actual income verification. As I mentioned, they've already done the appraisal. They look at what the equity that you're going to put into the house, or the amount of your down payment. If you have a certain down payment amount, the bank may require you to get mortgage insurance. This is a policy of insurance that the bank buys to cover them in the event that you default on your mortgage payments. All of those things play into the full approval or the commitment from the bank that basically confirms that they can loan to you the amount of money that you are asking to borrow. Just quickly see the chat there. Oh. Okay, so next. So let's assume that we've we've been to the bank, we've got our pre-approval, we know what we're looking for. We've now found a house that we like, and it's up for sale. So what do? We do the offer to purchase. So the government of Manitoba has a prescribed form for residential purchases. There's one for houses and one for condominium corporation or condominium unit purchases. And the concept is basically there's a standard set of terms and conditions, promises, obligations that the government feels should be in place for every purchase of residential real estate in Manitoba. Most people or the majority of real estate transactions will make use of a real estate broker or a real estate agent. I only want to mention that the important consideration here is when you're looking at purchasing a house through the use of a real estate service, it's important that you know who's actually representing who. So there's typically a listing broker and a selling broker. But you need to know, is the person that I'm dealing with, the realtor, are they actually acting as agent for me, or are they acting as agent for the vendor of the property, the seller? Also important to know is what the commission structure is, who's going to pay the commission, and when will the commission kick in. This brings me to sort of a recent development, which are real estate services agreements. And so this is a new concept that just came down in early 2022. And the agreements are put in place to describe the services that a realtor will provide, what the costs are, and how the agreement can be terminated. So you may have heard of listing agreements. This is intended to replace it. The key here is service agreements are not intended to impose obligations on you that you're not prepared to accept. Sorry, I think I went back a slide. How do I get back there? Wait, bear with me 1 second here. Here we go. Sorry about that. Okay. The main thing is, if you're signing a real estate services agreement, it's very important that you read the terms carefully, ask questions of the realtor that you're dealing with before signing, so that there's no misunderstandings. Obviously, the agreement is put in place to tell you what the realtor is prepared to do for you and how they intend to be compensated. It's important how the parties agree that if the listing isn't working out, how can we get out of the agreement prior to expiry? So it's really to set forth a better understanding between the agent and their client. Next. So just a brief bit of terminology here. So we talk about offers. What is an offer to purchase? An offer at law is a unilateral contract which is made by, in this case, a potential purchaser that is capable of acceptance until expiry or withdrawn. So I write up an offer to purchase with my deposit check. I give it to my realtor, and the understanding he's going to give it to the selling broker. I have to know that that offer can be accepted at any time until the expiry or until I actually withdraw my offer. I take positive steps to say that offer is no longer valid. So it's not recommended that you make offers lightly, or that you would, for example, have offers on two different properties at the same time. The understanding being that they can both be accepted, that they aren't conditional upon one or the other. It's also critical, because it can be accepted at any time by the vendor, to clearly state all your conditions in the offer if you have conditions. So there are some aspects that the standard form of offer to purchase draws to your attention, such as financing and things of that nature. But it's very important that if you don't have financing arranged, or you're not sure about it, that you make your offer conditional upon financing. We'll come back to the conditions in a second, but the main point I wanted to leave you with is if you make an offer, that offer is capable of being accepted unless you put additional conditions upon it. Going along with that is a counteroffer. A counteroffer is an offer that has been made, and the party who receives it comes back with a variation to one or more terms of the initial offer, and in that case also capable of acceptance. So I made you an offer, I'm going to buy your house, I'm going to give you $100,000. You come back and say, I accept the offer to purchase, or the purchase price would be $110,000. That counter offer I can accept at that time, and we have a concluded transaction, concluded a contract at that point once I've accepted that counter offer. So again, the key here is just be very careful if you're making offers, counter offers. You have to understand that once those are made, they're capable of being accepted until such time as they expire or withdrawn. So I'll just briefly talk about expiry. I don't have anything up on the slide, but your standard offer to purchase does state that the offer will expire if not accepted by such and such a time or such and such a date, and that's for the benefit of the purchaser. It's important that the purchaser put a date or an expiry date on their offer, so that it's not, that offer isn't just always there, always capable of being accepted. If I'm a purchaser and I'm making offers on, say, the fall, this weekend coming up, I might want to know that I might state that my offer will expire on April 18th, unless it's accepted beforehand. That way I don't have to be mindful of, on April 19th, withdrawing all my offers and then moving to the next round of houses that I'm going to look at. I can comfortably rely on the fact that that offer I made on Friday will expire on April 18th. If it's not accepted beforehand, fine, I can move on to the next set of properties that I'm going to be looking at. Just a brief point on multiple offers. I think it's fair to say the current situation in Winnipeg and Manitoba, and it seems like all across Canada, listed properties usually attract competing offers, more than one offer. The situation is often high pressure and it's intense because people get into bidding wars, and people start to feel like things are maybe not being done above board. Multiple offer situations, there's nothing wrong with them. The brokers must present all offers. The vendor is open to select the offer that it wishes to accept. So the vendor does not need to accept the highest bid, the cleanest offer, the best offer, or any offer. It's entirely discretional upon the vendor to decide whether or not they wish to accept any of the offers that are made. I just put in a quick link there, and there's also some links at the end that it sort of talks about the multiple offer situations. And so the key here is basically in this current real estate market that we're working in, it's not uncommon for multiple offers to be made. It's not uncommon for agents to create short lists, compare offers, encourage bidders to increase or change their offers. It's basically the situation that we currently live in. Okay. So we'll talk briefly about the contents of the offer to purchase. So the idea here that behind the prescribed form is the government is sort of giving everyone guidance. This is how we'd like your offer to like standard offer to purchase to look like. So the first thing obviously is the parties. Who's the purchaser? Who's the vendor? Sometimes we have situations where purchasers will want to buy a residential property through, for example, a corporation. They're going to buy this property for the purpose of renting it out to other people, turning it into a residential tenancy situation. So you see clauses where the purchaser will be signing an offer on behalf of a company that hasn't been incorporated yet. The idea being that the offer is being made in contemplation that if it's accepted, a corporation will step into the place of the purchaser and conclude the deal. The next section is the subject matter of the offer. So this is usually where you see the residential address or the unit address for a condominium. It talks, there's a section that talks about items that are included with the property, and this is where we have a description of fixtures. Fixtures are things that are fixed to the real property. Fixed, I use in quotes. This is stuff that is bolted to the ground, screwed into the land. Things that are not easily picked up and moved around are typically thought to be fixtures. So the idea is when you're viewing your residential property that you'd like to purchase, you're walking around and looking at things like, you know, the pipes and light fixtures and railings and stuff like that. Those are fixtures in the property. The expectation on closing is that those items will remain. They will not be removed from the wall. It won't be stripped down to the studs or the wallpaper. But the exception is unless they're listed. And oftentimes you'll see situations where, for example, a chandelier or some other fixture that is maybe of significance from a family perspective, the vendor will specifically state, you know, that this fixture is going to be removed, and that is basically allowed by the offer to purchase, and it's an understanding that goes between the purchaser and the vendor. Hey, this fixture is not included. Going along with that is excluded items. So this is where we look at things like contents, things that are easy to pick up and move, furniture, clothing, things of that nature. The expectation on closing is that the purchaser is not buying those items unless specifically listed. So sometimes things like, you know, appliances might be excluded, they might be included. It's just very important to be very clear on the offer to purchase in the event you're doing this yourself or you're speaking to a realtor. Hey, if there's something that's important in the content side of things that, you know, maybe the vendor has told you, by the way, the patio furniture is staying, it's very important that that be listed in the excluded items as being remaining with the property. Otherwise, on closing, the vendor is free to just pick up that patio furniture and leave with it. So, summarize on that point, things that are fixed to the land, fixed to the buildings, those are typically thought to stay unless specifically excluded. Contents, things that are easily lifted and removed from the property, those are specifically thought to be, or typically thought to be excluded or removed from the property unless specifically listed as staying. Next item up is the purchase price. So this is where we have a description of what the deposit with the offer is, what the mortgage proceeds are going to be, what the remaining down payment will look like. I should stop for a moment and say that there is currently a standard form offer to purchase that you can pull down from the website link that I've got at the very end. But there also is a movement or some movement that standard form offer to purchase may be significantly revised in the next short while. But for right now, this is what we're working with. And so anyway, stay tuned. If you're in the residential real estate business, you'll be interested to see what changes come down the pipe. A brief point about deposits. Sometimes people ask me the question, you know, what's an appropriate deposit? It's really more a question for a realtor as to what the level of, you know, the value of the deposit should be on the purchase of a residential property. But I will say, you know, from a legal perspective, the deposit is important because it shows that the purchaser, the potential purchaser, is serious about making the offer, is serious about coming through with their obligations, is willing to put down some of their money, and is capable of putting down some of their money for the purpose of securing that offer to purchase. So a low deposit, no deposit, those are typically red flags from a legal perspective. Okay, next up is the possession date. This is the date on which the purchaser takes possession of the property. The full purchase price is due. Fire insurance takes effect, and the ownership interest transfers from the vendor to the purchaser. I've got a note there saying there's a registration delay, and that is still currently the case. Our land titles office has moved to an online registration, but it isn't same day registration. So there is a period of time where the purchaser is the quote unquote owner of the land. They're entitled to possession. They're entitled to ownership. The fire insurance takes effect. But for a period of time, the vendor will still be registered on the title of the land titles office until that actual registration is completed and accepted and verified. Okay, next. The offer to purchase provides for certain promises from the seller. These are standard promises about the status of the property. Is the property situated within the lines of the legally described land? Are there encroachments, meaning properties from the neighboring land onto your land, or are there buildings on your land that are situated on your neighbor's lands? Those are all things called encroachments. Title and ownership, it's a standard promise that the vendor has good and valid title to the property. And then there is a clause that speaks to the seller's promise regarding goods and services taxes. Basically, if it's a sale of used residential property, then GST is not applicable. Brief word about property disclosure statements. This is a voluntary thing that a vendor can fill out and complete as part of the offer to purchase. The provincial government has again set forth a standard form, but it's important to note it's not required. If you're a vendor, there are circumstances where you may want to give a property disclosure statement. This is where you would want to draw specific attention to existing property defects. You're trying to educate the purchaser, tell them that for example, the basement is flooded the last 3 years. Something to try and make sure that the purchaser is aware that there's a defect with the property right up front, so that there isn't any sort of misunderstanding following the closing date. If you're a purchaser, you would like to have that disclosure as much as possible. You want to receive the information. You want to make sure it's accurate, gives you a full understanding of what the actual property you're buying is. And if it turns out that there's any inaccuracies, or if the vendor has made statements that are incorrect, it could be the basis for an action following closing. And by an action, I mean a claim. Okay, next we get to conditions. So just in general, a condition in an offer, in the context of an offer, it's an event, an action, a circumstance that must have occurred, been satisfied, or waived prior to the party's obligations becoming enforceable, i.e. an unconditional contract. So that's a mouthful. What it basically is if I put a condition on an offer, it means my obligations under that offer will not be legally enforceable until that condition has been satisfied. So again, just reiterating myself a little bit here, but purchasers must take care to ensure that they complete, that they can complete a purchase. So one of the most common conditions you see is financing. I've made you an offer based upon my pre-approval. So I'm going to buy your property for $100,000. I have a pre-approval for a $100,000 mortgage or $90,000 mortgage. But the pre-approval is not the same thing as having full unconditional approval from the bank. So I can make that offer, but I still probably want to have that offer. I still want to have that offer subject to financing, because I know that the bank's going to send an appraiser. They're going to want to do a full look at me from the credit perspective and confirm that I can actually borrow that money. So most people, sometimes they think that financing, that pre-approval gives them all the comfort they need to make that offer unconditional. And sometimes that turns out not to be the case. So I always caution people, if you're a purchaser, you do want to have financing approval in there. Other examples are, home inspection. I'd like to send someone in to do an inspection. Property disclosure statements. A statement about the working order of the appliances on closing, lawyer's approval. These are all examples of different conditions purchasers might ask for. Vendors typically don't have that many common conditions, but lawyer's approval is a good example. That's where, I've accepted your offer, but I'd like my lawyer to take a look at it and make sure I haven't accepted anything that I can't deliver as a vendor. Another one is a 48-hour clause. This is basically, I as a vendor, I've accepted your offer, but your offer is conditional upon financing and home inspection, for example. If I ask for the 48-hour clause, what I'm saying is I want the ability to let you know that, you've got 48 hours to drop your conditions and close the deal. Conditions generally. So this is a mutual set of conditions that the standard offer to purchase contains. So this talks about everyone making reasonable efforts to satisfy their conditions. If their conditions have been satisfied, they agree to be responsible and notify the other party. And if conditions are not satisfied, then there's a standard condition saying that the vendor directs the release of the deposit to the purchaser. So basically, the deposit is returned without deduction. Okay, I'm sort of maybe getting a little tight on time, so I might speed up here a bit. So the next section of the standard offer to purchase, mutual promises. This is where the parties agree to adjust for taxes, common element fees, other charges that form the property. The property is at the risk of the vendor, which means the vendor has to keep it insured until the possession date. We talked briefly about deposit forfeiture. So if conditions are waived or satisfied and the deal doesn't close, the offer provides the deposit is forfeited to the vendor, so the vendor gets to keep the deposit. But note that does not act as a waiver for further claims. It's not as though the vendor keeps the deposit but doesn't have an additional claim in the event it suffered additional damages. And then, so we talk about client closing and time of the essence. So again, this is just a general statement that these people will act expeditiously to make sure that they're looking after their obligations. And then survival of promises. This is where a section where if the vendor has made certain promises with respect to the status of the property, and you want to have a period of time after you possession date to verify those promises, you would insert this good working order clause, for example, that survives the closing. What that means is anything that isn't stated as surviving the closing date, as of the closing date, it merges and is no longer in effect. Deadline for acceptance. So we did also talk about this a little bit earlier. This is your expiry date. If you're a purchaser, it's important that you put an expiry date or a deadline for acceptance on your offer. Then you can always extend it or ratify it at a later date. Okay. So again, financing. So we've got the signed offer to purchase. We are now generating mortgage approval or mortgage commitment. The mortgage approval or the mortgage commitment, this is the agreement with the financial institution or lender to provide a loan, and the loan is on security of a mortgage. Some additional items that might come up in that mortgage approval or commitment, whether or not you need a cosigner or a guarantor. You need a minimum amount of equity, your down payment. Sometimes there's gifts of cash from parents or gifts to assist with the purchase of the property. Appraisal and survey and zoning confirmation. We'll come back to those ones in a second. Other conditions to satisfy. So if we're talking about a home inspection, appraisal, or reports, these are all the purchasers, if they form part of the offer to purchase. The purchaser is responsible to arrange and notify on completion and satisfactory results. So if I'm a purchaser and I ask for a home inspection condition satisfied within 7 days, that 7 days comes and goes and I haven't done anything about it, I'm probably not going to get an extension of that condition. And if you're a vendor, you should insist that there are timelines on those conditions and that they are satisfied within those timelines stated in the offer of purchase. You don't want a situation where I've agreed to sell my property on April 30th, for example, and the condition date for the home inspection is April 15th. I need to know by April 15th whether or not that deal has been, that condition has been satisfied, because that remaining 15 days, if I need the deal to become unconditional, the purchaser needs to either waive that condition and move to closing, or on April 15th, if they can't satisfy that condition, then the deal should be considered terminated and I should be able to walk away as vendor, sell to someone else. So that's basically what the waiver satisfaction is all about. Once the conditions are satisfied, the deal becomes unconditional and the parties are now obligated to close the transaction on the possession date. Okay, so closing of the transaction. So if you're the purchaser, your responsibility is purchaser's lawyer. You're responsible to satisfy the mortgage commitment. So you need to prepare and execute the mortgage documents, obtain survey or zoning or title insurance, any other items that are required by the lender. Purchaser is responsible to ensure that there's fire insurance on the property. And fire insurance, if you're getting financing, the fire insurance will have to name the financial institution as a loss payable. And last but not least, the purchaser has to come up with the balance of the purchase price and the closing costs. And closing costs will come to in a second. If you're the vendor's lawyer prepares the transfer documents. One of those transfer documents is a statement of adjustments. This is where we do a calculation on how we're going to adjust for realty taxes, which are due throughout the year, other amounts that are payable by the owner and adjusted between the parties. So a good example, other than taxes, might be common element fees if you're buying a condominium. Most purchases don't occur on January 1st, where there would be no adjustment of taxes, for example. Most purchases of property occur in the middle of a month. So you might have tax payments either on an installment program. One way or another, taxes are always adjusted, and there's usually other things to adjust for as well. And it's basically just taking the cost of whatever the charge is, the taxes, the common element fees, and dividing by the number of days, multiplying it out, and giving the purchaser responsibility for its share and the vendor responsibility for its share. So closing costs. There's a lot here, but again, we're getting a little tight on time. So I'll just tell you that typically what happens, the lawyer for the purchaser will prepare a budget sheet that gives you an understanding of what your anticipated or estimated costs are. You'll need the statement of adjustments for that, and also to know how much the deposit is down, what your cash to mortgage is. But then we have what are the additional costs. The biggest one by far nowadays is usually, well, I shouldn't say by far. The two biggest are land transfer tax and mortgage insurance. Land transfer tax is levied by the province of government, or province of Manitoba, and it's charged for the transfer of land, and it's a value-based tax. So it's graduated scale, but basically your first $30,000 is free, $30,000 to $90,000 is $300, $90,000 to $150,000 is $600, further on up the scale. When you get to value over $200,000, it is 2% of that amount. So you can see how it wraps up real quickly as property values increase. Most properties nowadays, you're going to be looking around the 200,000 or north range. So you just need to prepare for that cost. CMHC or mortgage insurance. This is an amount that is deducted by the financial institution to ensure the mortgage default insurance. So if you have less than 20% down, i.e. 20% loan to value, the mortgage insurance will be required. So if you're buying a $100,000 property and you're putting $20,000 down, you might be able to to get away without having that mortgage insured. If you're buying a $100,000 property and you're mortgaging anything more than $80,000, you will be required to get mortgage insurance. The premium for that is a little difficult to calculate, so I won't give you a breakdown on that, but if you are interested, I've got a link at the end for CMHC. But the main thing to know there is if the bank tells you they'll lend you up to $100,000, that mortgage insurance premium will be deducted from those mortgage proceeds. So if it was $5,000 for the mortgage insurance premium, the actual amount that they're going to lend you is the $95,000, not the $100,000. They will deduct that $5,000 right off, and that'll be part of your mortgage. There's a survey and zoning cost. This is a cost to have the survey prepared for a property. Note nowadays it's not strictly speaking a requirement to have a survey of the property or zoning confirmed. You can forego that cost by buying what's called the policy of title insurance. The policy of title insurance is a one-time fee where you pay for an insurance policy that more or less guarantees your interest in the property, but also the lender's interest in the property as well. The key here is the title insurance will cover you for existing defects on the title. It will not cover you for any defects of title that you have created on your own. So basically, the policy title insurance covers you as of the day you move in. If you make any modifications to the property, anything to the title after that fact, and the problem arose from those modifications, your title insurance will not cover you. Legal fees. So generally speaking, your legal fees will be, if you speak to lawyers around City of Winnipeg, generally speaking, everyone works on flat fees. But it is important to read the fine print on what's excluded, what's included in that flat fee. And, just be careful. Like anything in life, you get what you pay for. So the cheapest isn't always the best. As I mentioned earlier, your purchase price is due immediately on possession, but often there's a little delay in terms of the title and mortgage getting registered. So the period of time between the purchaser moving in and the date that the mortgage proceeds are paid to the vendor, the purchaser will pay some interest on that. And then, of course, there's miscellaneous disbursements for taxes, couriers, photocopying, title searches, that sort of thing. Okay, so briefly on possession date, the vendor will cancel its tip program and any other prepaid expenses like, alarm systems, things like that. The vendor will read the meters and call in their accounts. The accounts are their responsibility. Gas and electricity follow the vendor, but water sticks with the property. So it's always important, and water accounts unpaid can be treated by the City of Winnipeg as taxes. So it's very important that the vendor calls in and reads their accounts and sets up the final billing. The vendor is required to vacate the property and remove all their contents and leave the property in the same condition as when it was viewed or stated in the offer to purchase. And what this means is there's no material damage and no waste or debris left behind. On the possession date, the purchaser enters after the date and time of possession. So my possession date is April 1st at 9 a.m. I'm not legally permitted to go into the property until April the 1st at 9 a.m. My insurance will take effect only upon April the 1st at 9 a.m. Purchaser reads its meters, also calls in the accounts. I always recommend people change the locks, and the purchaser will notify their lawyer if there's any material damage, collection of waste, debris left in the property. The purchaser's lawyer is responsible to submit the transfer and mortgage documents for registration. They will request the mortgage proceeds from the financial institution and pay those to the vendor's lawyer. And at the end, the purchaser's lawyer will report to the financial institution with a clear title and registered mortgage. The vendor's lawyer, they're responsible to pay out the vendor's existing mortgage. So I'm selling the property. Well, I don't get to just leave behind my Scotiabank mortgage. I have to pay that out. give the purchaser clear title to that property. So my lawyer will be, as vendor, my lawyer will be instructed to pay out my Scotiabank mortgage from the proceeds of sale. The vendor's lawyer also pays the real estate commission and reports to their client with the net sale proceeds, provides clear title to the purchaser's lawyer. So the end result, if everything goes as planned, title is registered in the name of the purchaser, subject only to the purchaser's mortgage and any other encumbrances, caveats, and things like that that the purchaser agreed to assume. And all proper adjustments will have been made between purchaser and vendor. Briefly, buyer beware. So this is a concept where the purchaser is typically not going to be successful bringing a claim against a vendor for defects that it could have investigated and found out on its own. So this reinforces the importance of conditional offers, the home inspection, the property disclosure statement, well testing. Basically, if I'm a purchaser and I buy a property and I don't do any investigations beforehand, I don't look to find out, what the status of the foundation is a roof leak, has the basement flooded, I have a very hard time claiming against the vendor after the fact if any of those things occur. It's buyer beware, and it's very strong presumption in this province that if I haven't taken any steps to try and find out these problems on my own, I will not be successful in a claim. There are exceptions. This is when the vendor makes an actual disclosure. So I'm viewing the property and I walking around the basement, I say to the vendor, is the basement ever flooded? And the vendor says, no, it's never flooded. Well, that could be an exception to the caveat emptor. As buyer, I've tried to make inquiries, I've tried to find out, but the vendor basically misled me. Property disclosure statements, again, so the vendors, instead of verbally telling me something, they've told me something in writing that turns out to be inaccurate. All the things that I've relied upon these statements in buying the house. I wouldn't have done it had I known the truth. And then there's hidden or concealed defects. This is the classic example of, the new, wall board put up in the basement to cover last year's flood. Those types of situations can lead to a successful claim by a buyer, because the theory is that if you've taken steps to hide or conceal a defect, the buyer beware presumption shouldn't apply. I couldn't have been aware. You hid it from me. Okay, condominiums briefly. So I think we touched about this a little bit, but this is a form of ownership where there's a shared interest in the land and buildings, and it's managed by the owners of the units in common. So the ownership of a unit gives the owner title to a legally described unit plus a defined interest in the common elements. Owners, in as much as they're the manager of the property, they're also responsible for all the expenses of maintaining the condominium, maintaining and repairing the condominium project. Condominium, once it's established, the project has bylaws that govern the relationship between the owners and the management, which is a board of directors elected by the owners. And typically, there's a set of rules and regulations that specify how owners interact and how they may use their property. This is the example of no clothing line on the balconies, no barbecues, that sort of thing. Owners have a right to vote for the board of directors based upon their percentage interest. Condominiums are required to have reserve funds. They typically charge common element fees and other expenses. Those are all the responsibility of the owner. The purpose of the reserve fund is it's set up for the condominiums maintenance and repairs expenditures. And the last thing I'll say about condominiums, I mentioned earlier, there's a specific form of offer to purchase for condominiums. It requires that the condominium corporation provide certain information on the status of the reserve fund, copies of the bylaws, the rules, the regulations, things of that nature. And there's a cooling off period by law where the offer to purchase made by the purchaser. Until they've received that disclosure, they have a certain period of time after that fact to actually repudiate the offer to purchase or reject it. So until I've been provided that disclosure, my cooling off period doesn't kick in. But once I have that information, I then have a certain period of time before I have to actually sign off on that cooling off period and saying, yes, I'm going to proceed with the purchase. Okay, boy, I ran it right to the end here. So there, again, I've just put up some helpful links for information. So the Manitoba Securities Commission, Manitoba Real Estate Association, Canada Mortgage Housing Corporation. I recommend all of these websites that are here. They all have very helpful information. It's all basic information. It's very user-friendly, very reader-friendly. I mean, I would still recommend, if you have real legal issues or your rights are at stake, you consult a lawyer. But if you're looking for some background information, these are all excellent sources of information. And I don't know if I left any time for questions or comments, but I also don't know if there are any questions or comments. So I'll stop sharing here.
Okay, thank you so much for that, Donn. I don't see any questions that have come in, but if anybody has a question in the last minute or so here, I encourage you to put that in Q&A. Maybe we'll just wait for 30 seconds here and see if anything else comes in. If not, then we can wrap up.
I don't know if you make available the presentation to people, I can certainly pass them along to you, and they can, if anyone requests it, I'm happy if they would like to have it or want to send me any questions after the fact, that's fine too.
That sounds great. And I see in the chat here that people are thanking you and saying that they got lots of useful information out of today's presentation. So that's great to hear. Okay, I don't see any other questions coming in. So again, thank you so much for your time. And I guess we'll end here today. So have a good night, everybody. And thank you to everybody who attended as well.
Thanks so much, everyone.